Thank you. And now our next speaker is Tim Belevetz, who is from ICE Miller and is going to give us an overview of the year in review. As I promised to Ariana, I would not overrun, and I've already failed fantastically readily at the very first opportunity to keep to time. So I will swiftly hand over to Tim and let him introduce himself and his overview. So Tim, over to you.
Thank you very much, Patrick. It's a pleasure to be with you all this afternoon. It's actually morning here in Washington, but pleased to be here. I'm a partner in the Washington, D.C. office of ICE Miller, where I focus on white-collar criminal defense, internal investigations, government investigations, and corporate compliance. I'm a former federal prosecutor. I spent 12 years with the Justice Department at the U.S. Attorney's Office in the Eastern District of Virginia and at what we call Main Justice in the tax division. I also spent several years at the Securities and Exchange Commission in the Division of Enforcement. So most of my background during my practice has been with the federal government. And all of my career has been devoted to fraud, prosecuting it civilly, prosecuting it criminally, and defending it both criminally and civilly. What I'd like to do is spend the next 25 or 30 minutes talking about developments in 2020. There's a lot to cover, so I'm going to go fairly quickly. This year has seen a lot of activity, specifically with respect to some significant resolutions. There have been a number of developments with respect to FCPA enforcement. And this all, by the way, is despite the challenges of the global coronavirus pandemic that the world has faced for most of the year. But I'm going to talk about some of the prominent takeaways, which include some record-breaking resolutions, changes to policy pronouncements, including those related to cooperation among international anti-corruption agencies, and some rare judicially created law. Let's start off with some significant resolutions. It really was a record-setting year for resolutions, and this year we've already seen the largest amount of penalties paid in any single year, at least on the U.S. side. And this, by the way, is all with another month and a half left in 2020. The year started off with a landmark settlement with Airbus that David mentioned a little while ago. On January 31st, Airbus, the multinational aerospace company based in France that I know everyone is familiar with, settled anti-corruption charges brought by the French National Financial Prosecutor's Office, the PNF, the UK's Serious Fraud Office, and the Department of Justice. The company entered into deferred prosecution agreements with all three agencies in which it resolved allegations that it had used third-party business partners to bribe government officials across Africa, Asia, and the Middle East, as well as Latin America, and had bribed airline executives to obtain certain business advantages, including aircraft contracts. It really was a massive, massive fraud undertaken over a number of years. The 3-year U.S. deferred prosecution agreement related to a two-count criminal investigation, two-count criminal information charging the company with 1 count of conspiracy to violate the anti-bribery provisions of the FCPA and 1 count of conspiracy to violate the Arms Control Export Act and its implementing regulations ITAR, or the International Traffic in Arms Regulations. As part of the Judicial Interest Agreement, or DPA, with France, which settled allegations of CEPIN II violations, the French Anti-Corruption Agency will serve as a monitor. The DPA with the SFO in the UK resolved allegations that the company violated the UK Bribery Act. So here's what's interesting about this. Airbus paid nearly $4 billion, 3.6 billion euros in global penalties to the US, France, and the UK. I really should put France first because the largest portion of that went to France. Now, this was then, from the US side, it was then the largest resolution in the history of the FCPA. But most of these $3.6 billion euro recovery went to France. Nearly 2.1 billion euros, or $2.3 billion, went to France. What else about this? In addition to its size, a key feature of this resolution is the DOJ, I think, is the DOJ and SFO's willingness to defer to another agency with respect to monitoring. Both of these leading enforcement agencies stepped aside to let a very competent agency here, France's AFA, take the lead in monitoring Airbus's compliance efforts. And again, that will go on for a period of 3 years. The resolution, by the way, was the culmination of a multi-year investigation triggered by a whistleblower complaint to the SFO. So yet another excellent example of international cooperation among these anti-corruption agencies. The next significant resolution I'd like to highlight is, of course, the Goldman Sachs resolution, which was announced about 3 weeks ago. David also mentioned this in the last session. This, of course, involved the U.S. investment bank, Goldman Sachs. In this case, senior Goldman employees were alleged to have used a third-party intermediary to bribe certain high-ranking officials in Malaysia in connection with the Malaysian Sovereign Wealth Fund, 1MBD. We've heard a lot about that over the last several months, and officials in the Emirate of Dubai. Goldman subsidiaries, in this case, acted as arrangers or buyers of $6.5 billion of 1MBD bond offerings. The firm settled the case by paying a total of $2.9 billion or 2.46 billion euros to the DOJ and the U.S. Securities and Exchange Commission. The DPA with the Justice Department requires Goldman to pay part of the settlement to the SEC and other enforcement authorities in the US and in the UK, as well as Singapore and Hong Kong. And this, by the way, this settlement is on top of the $2.5 billion fine that Goldman had already paid to Malaysian authorities. So this was a big matter for this very large investment bank, multinational investment bank. So what is it about this particular case that's interesting? It stands out, I think the resolution stands out for a couple of reasons. At $2.9 billion, it's the largest settlement in FCPA history, a record-breaking largest settlement in FCPA history on the US side. In addition, it was really the result of some extraordinarily extensive cooperation among international authorities and US agencies. So yes, the DOJ and SEC were not the only US agencies involved. The Federal Reserve, the Fed here in the US, the state of New York were also involved. But extensive coordination among all of these agencies within the United States and abroad. Another sort of notable feature with respect to this settlement, I think it serves to highlight the very complex anti-corruption environment for highly regulated industries that are seeking to do business with government agencies. We'll continue to see that, I think, as time goes on. You'll see it in the healthcare industry, for example. You see it in airlines, and you see it as well in finance. These are very highly regulated industries that have contracts, extensive contracts with the government. I want to talk now about some important policy developments that we've seen so far in 2020. In June, the DOJ issued a very important update to its guidance to prosecutors regarding the evaluation of corporate compliance programs. Again, David mentioned this briefly earlier. The DOJ first released its compliance guidance several years ago in 2017 and has now updated it twice, in 2019 and then again in June of this year. The guidance is now placing an increased emphasis on evaluating programs really on a case-by-case basis relative to a company's, and this is right from the policy, relative to the company's size, industry, geographic footprint, and regulatory landscape. The guidance really recognizes that there is no one-size-fits-all formula for an effective program. So it's a bit of a departure from what we've seen in the past. I would note briefly that the UK's recent guidance with respect to compliance programs also takes a sort of individualized approach to the compliance program. And there's been a lot of emphasis placed on this on the U.S. side with the fraud section at the Justice Department. What does your compliance program look like? Is it reasonably tailored to meet the specific risks of your company, of the areas in which you do business, of the way in which you're regulated? Interestingly, too, the new policy with respect to evaluating corporate compliance programs also places an emphasis on the program in place at the time of the conduct and the time that the charging decision has been made, on the one hand, and on the other, the program in place at the time of the resolution. So it takes into account that during the period of time when the conduct was taking place, and when the charging decision and resolution has been reached, how has the compliance program evolved? Is it the same as it was before? Have improvements been made alternatively? And if there's been improvement, then the Justice Department will take that into account in determining the effectiveness of the compliance program and ultimately the resolution of the matter. The other policy development that I think is worth noting is the second edition of the FCPA Resource Guide. Many of you I know are familiar with this. The guide was updated in July of this year. It was initially published by both the DOJ and the SEC and first released back in 2020. And this is the first time it's been updated by way of a new edition. It's a detailed collection of information and analysis relating to the FCPA and its enforcement. It really shows how the authorities in the United States, the DOJ and the SEC, interpret the law and interpret the case law that pertains to it. And I'll tell you, for those of you who may not be as familiar with it, it is really a fantastic resource in the sense that it's all in one place. It's broken down by subject matter. It's got some questions and answers. It's got examples. It now has the principal policies that have come out, including the policy I just mentioned with respect to evaluating corporate compliance programs, all in one place. And it really is an excellent place for compliance officers and practitioners to get kind of some quick answers, not necessarily everything you need to know, but some quick answers with respect to how the law is interpreted by these U.S. enforcement agencies. So this new edition that came out this year includes several changes that are intended to reflect new cases, new law, and new policies. So I want to talk about some of these specific changes. The first noteworthy change is the addition of a new section discussing the DOJ's FCPA corporate enforcement policy. This policy, many of you are familiar with, was first announced in 2017, and it provides, and I'm quoting here, where a company voluntarily self-discloses misconduct, fully cooperates, and timely and appropriately remediates, there will be a presumption that the DOJ will decline prosecution of the company absent aggravating circumstances. Now, obviously, there are a lot of parts to that. There's still a lot of room for interpretation. For example, what is an aggravating circumstance? Well, the guide gives some examples of aggravating circumstances and notes, by the way, that even where they exist, the Justice Department may still decline prosecution. So that's a very important addition to the new edition. The guide also references, I mentioned a moment ago, the DOJ's new corporate compliance program evaluation guides. So it's in sync with the new policy. The resource guide focuses really on three questions. Number one, is the company's compliance program well designed? Number two, is it being implemented effectively? And number three, does it work in practice? So the new edition, the guidance in the new edition affirms that both the DOJ and the SEC will employ a common sense and pragmatic approach which I think is very good news for companies. And use the questions in the guide to evaluate compliance programs, these questions that I just walked through. So where do you stand with respect to your compliance program, and is it going to be enough to end up leading to a reasonable outcome? May not obviate the prosecution related to the charges or related to violations altogether, but how can it mitigate the damage? These are all these questions that I just walked through that will help determine kind of that it will help guide where the outcome is likely to end up. Also in the FCPA resource guide, there's several other policy updates that are worth mentioning. It updates, the resource guide includes an update reflecting the Hoskins decision, which David mentioned a little while ago. I'm going to talk more about that in just a moment, but very briefly, in 2018, so 2 years ago, the U.S. Court of Appeals for the Second Circuit issued a decision in this case. This is an FCPA case that was brought in federal court, of course, and prior to trial, an issue was taken up to the federal appellate court, in this case, the Second Circuit, to determine whether non-U.S. nationals are subject to the FCPA's requirements based on theories of conspiracy or accomplice liability. So this doesn't necessarily, at the end of the day, doesn't necessarily pertain to a large group of people in the larger scheme of things, but it pertains to an important group of people that the SEC, that the DOJ is going, and SEC for that matter, will be focused on. So the Second Circuit, many of you may know, is a very influential appellate court in the United States. It's one of I think it's 11 or 12, 12 including the Court of Federal Claims. But it's considered to be among the most influential appellate courts, and while its holdings are binding only upon the states within the Second Circuit, which by the way includes New York State, its decisions are considered very influential throughout the rest of the country. Not necessarily the law of the land, but pretty close to it in some ways. So the guide, the new updated resource guide now notes that at least in the Second Circuit, which again includes New York, a foreign actor may be prosecuted for conspiring to violate the FCPA's anti-bribery provisions, or prosecuted for aiding and abetting violations of those provisions, only if there's a specific nexus to the United States as laid out in the FCPA itself. And this is a change from the 2012 edition. This will undoubtedly come as a relief in some ways, if not on a practical level, at least on a symbolic level, to those who worry or are concerned about the United States reaching out abroad to initiate enforcement actions where it seems as if there are few connections to the United States. It's not to say that that still can't happen, but at least with respect to this particular theory, again, conspiracy and accomplice liability. If the United States is going to prosecute criminally an individual who is in that category, there must be a specific nexus to the U.S. that's laid out in the FCPA. The resource guide also lays out the factors that the DOJ takes into account in determining whether a corporate monitor should be imposed. Which is another important update to the resource guide, and it makes clear that where, and again I'm reading from the quoting from the guide, that where a corporation's compliance program and controls are demonstrated to be effective and appropriately resourced at the time of the resolution, a monitor will likely not be necessary. Again, good news for companies that find themselves in the crosshairs of the DOJ and are looking at significant penalties. They may not have the added burden in ways that they used to of having to pay for and be under the supervision of a monitor for a number of years. The last important update I want to highlight from the resource guide pertains to post-acquisition due diligence and successor liability. And the guide now recognizes that while pre-acquisition due diligence may be imperfect, the DOJ and SEC will consider the timeliness and thoroughness. Again, I'm reading from the guide here. The timeliness and thoroughness of the acquiring company's post-acquisition due diligence and compliance integration efforts in determining whether to file an enforcement action. So, what you may have acquired a dog with fleas when you took over that other country, but what have you done since then to improve the compliance environment? These are factors that the government will take into account, which again I think is very good news. I want to talk now about some case law developments in our remaining few minutes. Cases interpreting the various provisions of the FCPA are rare, and I think David made a reference to that a little while ago. Most cases are resolved pre-trial, and those that do go to trial typically involve individuals rather than entities. Entities simply have too much on the line to take the matter to trial in ways that perhaps individuals don't. But I mentioned earlier the Hoskins case. I want to talk a little bit more about that. As a result of that Second Circuit Court of Appeals decision back in 2018, the FCPA, as I noted, updated its analysis regarding applicability of conspiracy and accomplice liability with respect to non-U.S. persons. That was, as I mentioned earlier, a pre-trial decision. So Hoskins then, in late 2019, went to trial. And this case, by the way, it seems like it's been going on for forever, and it's gone up and down in the appellate cycle. But he finally went to trial in late 2019. Who was the defendant? Hoskins was a British citizen working for the French conglomerate Alstom SA, who, by the way, never stepped foot inside the U.S. while working for the company. He was convicted, however, by a jury on nearly every count, several counts of violating the FCPA, and several more counts of money laundering. So that was the jury's decision in late last year. However, in February, as a result of a motion made by his lawyers during the pendency of the trial judge granted Hoskins's motion for acquittal on the FCPA counts, just the FCPA counts, not the money laundering counts remain, and the money laundering convictions remain. But the judge, on her own, pursuant to a motion by the defense, granted an acquittal for the FCPA counts. Why? On the ground that the prosecution failed to prove that he was an agent of a U.S. entity. So, following the Second Circuit's earlier decision with respect to conspiracy and accomplice liability, the government kind of changed its approach, changed its theory. So no longer trying to prove that he conspired or was involved in aiding and abetting a violation, rather that he was an agent of a U.S. entity. In other words, a whole different basis for finding him subject to the FCPA's requirements. The DOJ, the trial judge, and this is a technique that trial judges are under the federal rules of criminal procedure are allowed to employ, even notwithstanding a jury verdict. They can overturn the objection under certain grounds. If it happens, by the way, after the case has gone to the jury, as it did in Hoskins, then the Justice Department can appeal the decision to the circuit court, the appellate court. Normally, the Justice Department has to live with a verdict, but if this particular acquittal done by the judge happens after the jury verdict, the Justice Department can appeal, and it has. And the Second Circuit, the matter is pending before the Second Circuit, which will consider the limits on cases of individual liability that are premised on an agency theory. So it should be interesting to see what happens there. What big takeaway here, I think the decision was a significant setback for the DOJ, in part because FCPA cases are seldom litigated. The DOJ often takes an aggressive position with respect to jurisdictional issues, and frankly, there's not a lot of opportunity to test those positions because these cases really don't go to trial often. This one did. I think it was a setback for the DOJ. It may be certainly the first appellate decision in 2018 that we've discussed was a setback. We'll see if this one, how this one turns out, and see what happens with agents with respect to FCPA liability. Finally, I want to talk briefly about the another significant case law update, which is the Liu v. SEC case. This was a Supreme Court case that was that came out in June of this year. The U.S. Supreme Court in that case rendered a decision that upheld the government's ability to get disgorgement of ill-gotten gains in civil cases. That the disgorgement of illicit profits is often a key factor in determining the cost of an FCPA resolution with the SEC. The SEC, as many of you know, brings only civil enforcement actions. The Justice Department handles all federal criminal prosecutions. The SEC, however, does have a jurisdiction over the FCPA, but only with respect to civil enforcement actions. So this is an important decision with respect to disgorgement in civil FCPA cases. The lower courts in this case had allowed the SEC to recover the illegal profits without a deduction for even legitimate business expenses. And that really was the key issue here. Are legitimate business expenses be deducted from the amount that the defendant is obligated to disgorge as an equitable remedy? The trial court said yes. The appellate court, I believe it was the Ninth Circuit, agreed. The SEC, however, first upheld the SEC's ability to obtain disgorgement. So that was kind of one sort of threshold matter. So good news for the SEC in that sense. However, the Supreme Court went on to limit the amount of disgorgement by limiting what the SEC can obtain to the defendant's net profit after net profit from the wrongdoing after legitimate expenses have been deducted. So the good news for those that are charged by the SEC with FCPA offenses and are and resolve it and are required to, or even go to trial and are required to cough up the ill-gotten profits, you can in fact deduct your legitimate business expenses from what you have to pay over. So some good news in that regard for potential wrongdoers. That's really what I wanted to cover. I want to just kind of leave you with a few final thoughts, and I know our time's about up. It's been a busy year for anti-corruption enforcement at the SEC, at the DOJ, at the SEC, and elsewhere. And I think the volume of cases we've seen so far, and there's still a month and a half left again in the year, seem to bear out the senior U.S. officials' claims. There have been a number of them who've gone on record saying this, that despite the global COVID-19 crisis, the DOJ and SEC are still able to work with foreign authorities, and FCPA resolutions remain a priority. I think it's going to be interesting to see how the disruption caused by the pandemic may affect future enforcement actions. Will there, for example, be a delay in new cases as investigators and prosecutors face the challenges in conducting cross-border investigations? These are, after all, cross-border investigations. They require gathering of evidence and talking with people, interviewing witnesses abroad in many instances. And that's difficult under these circumstances that we find ourselves in. Will there be an increase, alternatively, in activity as dishonest executives see that compliance efforts may have lapsed due to the remote workplaces, and as resources are earmarked for compliance have shifted, perhaps temporarily, to other priorities. So we'll see what the future has in store. It'll be interesting to see what comes up.
Thanks, Tim. That was a fantastic run through everything. There were questions. Which are you able to hang around until the end networking session? Because there's some questions in relation to particular countries of focus and whether there will be a focus on COVID-type fraud cases, which it would be interesting to hear your slant on if you're able to hang around, because I want to pass on to the next group now. But if you are able to hang around, we'll deal with the questions later. If you're not, thank you very much indeed for your time, and I'll answer the questions in your answers from a UK perspective in any event. But that was an excellent outline. Thank you very much indeed.